Hi, everybody. I'm Joe Bingham, Senior Counsel and Natural Resources Practice Leader at Mountain States Legal Foundation. Mountain States is a nonprofit law firm that litigates cases in the interest of individual liberty and limited government. You can go to our website at mslegal.org to learn more about us. Our format today is pretty simple. We're going to start with each of the panelists introducing an aspect of this case, which is West Virginia versus EPA, argued this morning at the Supreme Court. And then we're going to go into a discussion about how the argument went and what might happen. And then we'll be open for questions and answers. If you have questions, you can submit them in the chatter Q&A box at the bottom of your, I assume the bottom of your Zoom screen like it is on mine. So first, let me introduce our panelists. We have Professor Jonathan Adler of Case Western Reserve University School of Law. He may be most famous as a member of the Volokh Conspiracy blog, but Professor Adler writes about many issues, including federal regulatory authority and policy in general, constitutional law, and environmental law, where he's one of the most cited professors in the field. Mr. Peter Wolfson is a senior fellow emeritus at the American Enterprise Institute, where he studies and writes on constitutional law and the administrative state. He just published a book with Professor John Yoo, collecting pieces on the Non-Delegation Doctrine, which is at issue in this case. They also had an editorial in the Wall Street Journal today about the case. He served as White House counsel under President Reagan and general counsel to the U.S. Treasury Department in the same administration. Mr. William Yateman is a research fellow at the Cato Institute's Levy Center for Constitutional Studies, where he works on administrative law, constitutional structure, and regulatory reform. He drafted the amicus brief that Mountain States and the Cato Institute filed jointly in this case regarding the major questions doctrine. So first of all, I was going to start by asking you, Professor Adler, if you could kind of introduce us to the background of this case that was argued this morning at the Supreme Court. You're muted, sorry.
Sure. So to understand this case, we got to do a little bit of recent history. So the issue in this case really goes back to a consent decree filed a little over a decade ago between the Environmental Protection Agency and environmental groups, where the EPA agreed that it would begin regulating power plants under Section 111 of the Clean Air Act. And Section 111 both allows for the setting of standards for new sources in a given source category, as well as regulation of existing sources. And as a result of that consent decree in 2015, the Obama administration put out something called the Clean Power Plan. And I'm oversimplifying a little bit, but basically what the Obama administration said was that its power to set standards that would produce that would constitute the best system of emission reduction for greenhouse gases from power plants meant not merely making efficiency improvements or operational changes at individual plants, but actually could also involve things like generation shifting and fuel shifting, such as substituting out coal production for natural gas and making broader changes within power production more broadly as a way of reducing greenhouse gas emissions. That rule was stayed by the Supreme Court in what we believe was, or was a 5-4 vote, and what we believe was Justice Scalia's last vote as a justice on the court. As we know, in 2016, the Trump administration is elected. The Trump administration decides that it not only doesn't like the Clean Power Plan as a policy matter, but believes the Clean Power Plan was based on an impermissible reading and unjustifiably broad reading of the EPA's authority under Section 111. The Trump administration's view was that read properly and in light of the major questions doctrine, Section 111 only allows the imposition of emission controls that can be done at the facility, what is sometimes referred to as inside the fence line. The idea being is that for decades, the way we've controlled pollution from stationary sources is by requiring individual sources to make changes at their specific facilities to reduce that source's emissions, and that was how the Clean Air Act should be read. It could not be read as written to impose broader system-wide emission reductions. On that basis, the Trump administration repealed the Clean Power Plan and replaced it with something called the Affordable Clean Energy Rule. Just as folks challenged the Clean Power Plan when it was adopted, the Trump administration adopts the ACE rule, the Affordable Clean Energy Rule, and folks challenged that as well. And that was challenged in the DC Circuit, and the DC Circuit, in a split decision, rejected the Trump administration rule, concluding that the Trump administration's statutory interpretation was not the only permissible way to read the relevant language, and that therefore the Affordable Clean Energy Rule was invalid. But as part of that, that would mean the rescission of the Clean Power Plan was also invalid. The DC Circuit then issued a partial stay of its mandate at the EPA's request so as not to reimpose the Clean Power Plan right away, because the Clean Power Plan had emission targets and timetables for compliance and the like that were out of date and that no longer couldn't be met in 2021 the way they could have been met in say 2016. So that is the opinion that was challenged today. That was the opinion that West Virginia and a bunch of other states, as well as several coal producers, sought certiorari on, and the Supreme Court granted certiorari on whether or not the DC Circuit's interpretation of the Clean Air Act was a proper interpretation of the act, or whether it was an impermissibly broad interpretation of the act that gave the EPA more authority than Congress had actually delegated through Section 111. So that's kind of the lay of the land in terms of how we got to this case.
Okay, thank you. So I guess the fundamental question is how much power the EPA has to regulate here, and that question implicates what's called the Non-Delegation Doctrine, which I was going to ask Peter to introduce to us.
Hey, thanks, Joe. I'm going to take a little liberty here and talk about two things rather than simply the non-delegation doctrine, because I think these two things are tied together as challenges to the administrative state. As many of you may know, if you looked at that article in the Wall Street Journal, John and I edited a book on the administrative state before the Supreme Court. And actually, the professor's article is in there too. But we wanted to take on the administrative state as well as simply the non-delegation doctrine. So I want to just talk briefly about the Chevron case, which was also brought up before the court this year. It's important to understand both of them are challenges to the administrative state. And the fact that the court took both of these challenges in the same year seems to me, or in the same term, seems to me to be significant. I think there are people on the court who want to do something about Chevron as well as about the absence of any final non-delegation doctrine. So if you don't mind, I'll go into the one case that involves Chevron, and then we'll go on to the non-delegation doctrine. But Becerra versus the American Hospital Association has already been argued. That's the Chevron case. Chevron says, and you can see why it gives so much power to the administrative state agencies. Chevron says that it's a judge-made rule in 1984, unanimously by the Supreme Court. And it said that courts should defer to the views of an agency about its powers if the statute is ambiguous and the agency's view is reasonable. And the result of that has been to make Chevron into one of the most important cases ever decided by the Supreme Court, certainly in the administrative law area, and has given much, much more power to administrative state agencies, because the courts, especially the lower courts, have said, well, why should I fight about this with this agency If they say they need this power and this is what Congress gave them, I'll give it to them. And that has worked out pretty well for the administrative state agencies. Some of the studies have shown that about 94% of all cases that are argued on a Chevron basis end up favorable to the agency. So what's happened is that there's been challenge now within the Supreme Court to the Chevron doctrine, as well as to the non-delegation doctrine issue, which I'll talk about in a moment. And that occurred in 2013 with a case called Arlington, City of Arlington, where Roberts, Kennedy, and Alito dissented from a decision by Scalia. And Roberts ended up saying, we do not leave it to the agency to decide when it is in charge. So there are three guys on the court right now who are very reluctant to give much more power to the agencies through, Kennedy has left the court, but he's been replaced by Gorsuch and several other people who are likely to be unsympathetic to further powers for the administrative agencies. So with that background, now we're going on to the non-delegation doctrine, which is similar in one sense to the Chevron case, because although Chevron says that courts should follow basically what the agency wants to do, as long as the agency's position is reasonable and the statute is ambiguous, we then get to something that is doing the opposite. The non-delegation doctrine would say you can't give any power to an agency, that is the power to legislate, that is the power to bind individuals, unless the Congress has made basically the major policy decisions that go into using that power. So in the case today, West Virginia versus EPA, the non-delegation doctrine was a possible course for the court. We don't know whether the court will actually use it. It does not have to use it, but I thought, and John, you and I thought it was interesting enough. This case was close enough to a non-delegation case that the issue might come up. But the non-delegation doctrine is, the purpose of it is to make sure that the separation of powers in the Constitution it works. It says Congress, which in the Constitution, as most of you probably know, in the Constitution as the legislative body, the body that is supposed to make the laws for the country, cannot delegate its legislative authority to any other branch. Madison, in the Federalist Papers, argued that if the power to make laws and the power to enforce laws, that would be the executive, were combined in the same entity or individual, that would be a threat to liberty. So our Constitution is fundamentally based on this notion that there should be a separation of powers between Congress and the executive. And the non-delegation doctrine does exactly what you would expect. And that is, it is saying Congress may not delegate to the executive or any other body its sole legislative power. Now, the non-delegation doctrine has not been invoked since 1935, and it was invoked in two cases that year, and not since. For one reason, perhaps, is that the court that invoked the non-delegation doctrine then was challenged by President Roosevelt with a court packing plan, and the court might have thought, at that point, oh, we've gone a little bit too far. And even though the court packing plan was not adopted, it was a good idea to back off. And after that, there were many changes in the court, many changes in the way the Supreme Court looked at legislation that made it much more difficult for the non-delegation doctrine to be adopted. But the courts were faced with non-delegation cases over the years, but in almost all of those cases, the court had adopted a very ambiguous and weak non-delegation doctrine, much different from the one that was actually invoked in 1935. And that ambiguous doctrine was called the Intelligible Principle doctrine. And so they interpreted this notion that Congress cannot delegate its authorities to something like this. Well, you can delegate your authorities, your legislative authority, if you give the agency some kind of set of principles, intelligible principles, that will guide them in how they are supposed to use the power that they have been given. And that was taken up very enthusiastically by the Supreme Court. And from 935 on, even though they took a number of cases where the non-delegation idea was introduced, what they did in each case was say, oh, no, wait a minute. We see in the statute and the surrounding material that what Congress had in mind was an intelligible principle. And you're supposed to abide by that. And in fact, we find that you did. And that has happened time after time at the Supreme Court up until now. And the result has been that it has been extremely difficult for the non-delegation doctrine to continue in force. The last case which invoked the non-delegation doctrine was by Justice Scalia in Whitman versus the Association of American Railroads in 2001. And in that case, the question was whether the law involved, it happened to be the EPA, had an intelligible principle. And Scalia, writing for a majority, said, "Oh yes, there it is. The EPA is required to do something that is requisite, that is not too much and not too little, to make sure that the air or water is clean." So requisite was the intelligible principle in that case. And after that case, many lawyers said, look, this non-delegation doctrine thing is dead. I mean, they have taken all of the power out of it, and the court will simply throw these things aside. Now, what happens in these cases when that occurs, when people think that's true, is that counsel no longer take cases to the court, or when they take a case to the court, they don't bother with the non-delegation doctrine. So there has been a big hiatus between 2001, when this Whitman case was decided by Scalia, and today. But there was one very interesting thing that occurred at that time, and that is Justice Thomas filed a concurring opinion in the Whitman case. And he said, this intelligible principle gets invoked, and I've sat here when we've done it many times, but it does seem to me that there's an awful lot of legislation being authorized for these agencies that are covered allegedly by the intelligible principle, but are not permissible under the Constitution. So that's Justice Thomas. He is a person who takes the Constitution very seriously, and he said we should really be invoking the non-delegation doctrine more severely. So in the West Virginia case, there are a number of issues, but the one that attracted John, you, and myself particularly was the EPA's requirement in the new rule that came into force during the Obama administration and was reinstated by the DC Circuit, or at least it looks as though it was reinstated. There's some argument about that, but it seems to have been reinstated by the DC Circuit. And it requires power companies that are burning coal or burning oil or even natural gas to make investments, quote, outside the fence, close quote, which means they would have to make investments in other power activities away from their area of responsibility, away from where their plant is, in order to reduce, at least this is how you could read that statute, in order to reduce, or that rule, in order to reduce the total amount of CO2 that they are emitting. And that looked to us, and you'll see that in the Wall Street Journal article, like something that would require a person to have solar panels on his roof in order to account for the fact that he drives his car a lot and puts a lot of CO2 into the atmosphere. So that seemed to be completely unwarranted by the very limited statutory language that was in the EPA statute. And so we thought, the court is going to look at this, and it is going to take the position that the EPA has gone well beyond what the statutory language says. There's just nothing in there that supports the idea that a power company has to make investments in something outside its normal activities that will actually reduce some of its CO2 emissions inside the fence, or where it is actually operating its power production. And if that is the case, the court could probably just turn this aside and send it back to Congress and say, look, Congress, if this is what you expected the agency to do, then we want you to take the responsibility for making that call, not the EPA. Now, we'll see what happens, but it seemed to us that the rule that the EPA had made in the Obama administration had been reinstated by the DC Circuit was so far away from what the language of the statute seemed to permit. It was so imaginative beyond what the statute seemed to be doing that it was also an opportunity for the court to say, well, wait a minute. Let's get one thing straight. If you have a statute, and they're talking now to administrative agencies, if you have a statute, and they could be talking also to the DC Circuit, if you have a statute that does not deliberately provide the kind of authority that this agency has used, then the non-delegation doctrine is implicated, and you should be thinking in those terms to use it. And that, I think, is why this case has been seen by many people who support the power of the EPA as a possible non-delegation problem, and one that they would like to eliminate. That is, they'd like to eliminate the non-delegation issue from this case. Well, we'll see what the court does. I think we'll have a report on exactly how they handled the case in the argument today. But I think my impression from listening to what the justices were saying is that the conservatives were very eager to move this regulation apart from the regular things that the EPA does, using the novel questions doctrine, or one of those canons of interpretation that tell courts that they shouldn't go beyond what the statute is actually saying, especially on very major kind of nationally important issues. Or they would have the option to invoke the non-delegation doctrine as a matter of principle, mentioning it, pointing it out to the courts in much the way that the court did in 1984 with the Chevron doctrine. Because in 1984, they just took this Chevron case, which was a normal case, and they made it into a major statement to the courts about how they should interpret administrative rules. So they could do the same thing now using the non-delegation doctrine. And that's why I brought Chevron up at the beginning. They could also, in the Becerra case, when they get to that, they could also eliminate the Chevron doctrine. And with this twofer, they would have eliminated much of the source of the administrative state's power to make rules. Thank you.
Thank you. Thank you. I'm going to try to zoom out for a second because I know we have a lot of non-lawyers, and administrative law in particular, I feel like there are a lot of different doctrines that interact in complicated ways. So the basic question in administrative law is how much authority do agencies have, and who decides how much authority the agencies have? And so as a conservative, I'm, skeptical of agencies having too much power because I don't want them to overregulate or interfere with individual liberty. But also as a conservative, I am skeptical of judges having too much power. And so the back and forth in administrative law is between how much power the courts are going to exercise in control of agencies and how much power the agencies get to exercise. And so you have the Chevron doctrine, which limits the authority of courts and says agencies have more power because they get to decide, as long as their interpretation is reasonable, what their enabling statute says they can do. And then you have doctrines like the non-delegation doctrine that give judges more power and say that judges should be able to throw an issue back to Congress if what Congress did wasn't really legislation, but rather the agency is legislating. So another doctrine that maybe limits agency power and is more deferential to what courts think would be the major questions doctrine, which I was going to ask Will to introduce for us.
So thank you for teeing me up that way, Joe. It's a perfect segue. So this major questions doctrine, one of the hottest topics in administrative law. It's an important interpretive principle that has been developing in the Supreme Court over the last couple decades. However, it's inchoate, as we'll get to. They haven't fleshed it out. So what is it? What is this major questions doctrine? It's a presumption that Congress speaks clearly when it delegates the authority to make policy that has major social and economic effects. You could say it is very much related to the non-delegation doctrine about which Peter spoke. Whereas the non-delegation doctrine is the courts reviewing legislation, how much power Congress is giving away. The major questions doctrine takes those principles and, in essence, applies them to the regulations pursuant to these delegations. That is the agency's expansive interpretation of an ambiguous statutory text. Does that reflect the agency going beyond its statutory delegation. So I guess another way to think, sort of a similar way to think of this major questions doctrine, and again, for the non-lawyers out there, I'm sorry if this loses you, but it's as a corollary to Chevron Step 2's inquiry into the reasonableness of an agency interpretation. So I know Peter spoke about this principle of Chevron deference. It's got famously two steps. At the first step, a court determines whether or not the statutory text is ambiguous. And then at the second step, it determines whether or not the agency is being reasonable. Well, in this major questions context, it's a good sign or a big sign that the agency is likely being unreasonable if it bases a major policy on a tenuous reading of a long extant statute. So those are the sorts of principles that make this doctrine operating.
By tenuous, sorry to interrupt, by tenuous meaning of a long extant statute, you mean, say, the statute's been here for 20 years and the agency's been doing its thing, but now it says that the statute allows it to do something it's never tried to do before in those 20 years. Is that what you mean?
Well, those would certainly be components, but in essence, an expansive reading of an ambiguous text. So yes, often an expansive reading of an ambiguous statutory text that engenders major policy will be unprecedented. So yes, that is by tenuous reading. I mean, dusting off a statutes that's long been on the books, and then in essence conferring upon yourself a great deal of power by undertaking an expansive reading of the statutory text. So I guess that's what I was getting at with the tenuous reading, if that makes sense. So the way I've been discussing this major questions doctrine, it's the weak version. So there is a stronger version of the major questions doctrine that's out there, and it was alluded to in the oral arguments this morning. And I'll be honest, I'm not entirely clear what this entails. Jonathan wrote about it in a blog post shortly after oral arguments. It's a broader presumption against the delegation of regulatory authority. Again, I'm not quite sure what this stronger gloss on the major questions doctrine actually entails. To me, this broader presumption against the delegation of regulatory authority seems coterminous with the non-delegation doctrine about which Peter spoke. That's the background of what the major questions doctrine is. I'll note very briefly that the DC Circuit in the decision below, that's before the Supreme Court in West Virginia v. EPA, that opinion, that majority opinion, in essence establishes the antithesis of the major questions doctrine. Perhaps the anti-major questions doctrine, for lack of a better term. The court read that the statutory, in essence, it said because greenhouse gases are a large problem, any regulation pursuant to this ambiguous the ambiguous provision at hand must be major. I mean, sort of a presumption in favor of major regulation. So that's troubling. I'll finally note that the $64,000 question when it comes to this major questions doctrine is, what is a major rule? How do you identify that? And I think, Joe, this touches upon your question of judges performing the role of policymakers, perhaps unduly. I mean, where do you draw this line? And it's engendered a great deal of confusion. It was the subject of a lot of questioning in today's oral arguments. I'll note here that the brief that we submitted along with the Mountain States Legal Foundation, we actually propose a framework to identify a non-exclusive list of criteria that the court could consider when it's trying to identify one of these major questions. And we use the facts of the case to bear these out. And I'll just briefly run through them. The first basically is the statutory context. In the case we've got here, the Clean Air Act, huge statute, foundational statute. All right, it sets forth two major regulatory programs. one for what's known as criteria air pollutants, and another that's known for hazardous air pollutants. Well, this Clean Power Plan, its authority is neither. It's this catch-all provision. Well, that doesn't really make any sense. I mean, Congress, it has this major Clean Air Act bill, this major legislation. It spends, scores of pages setting forth these two major programs. And then the EPA is going to tell us that in one of these non-major programs, in a catch-all provision, that the agency is authorized to regulate the entire electricity grid, that one of its most consequential, if not the most important regulation it's ever issued. I mean, that just makes no sense. And that becomes evident when you look at the statutory context. Another factor that was alluded to is whether or not the measure is historic. And, that's fairly self-evident. I mean, this Clean Power Plan, in the handful of instances when the EPA has exercised this particular statutory provision, 111D, it's been for far-flung industries like craft pulping and sulfuric acid production. Well, all of a sudden, you're going to tell me that it's the basis of regulating the entire electricity grid in one fell swoop? Well, again, that seems to indicate that we've got ourselves some major questions here. And then the final non-exclusive factor that we set forth was quite simply whether or not Congress has tried to do something similar. And again, this history was alluded to in oral arguments today, but the long and short of it is that the 111th Congress in 2009 and 2010 tried and failed to enact a so-called cap and trade climate policy. President Obama, famously, after winning a second term and no longer facing electoral accountability, said to the nation that he's going to reach for his pen and phone and accomplish that which Congress won't. And among the regulations engendered by this reaching for the pen and phone was the Clean Power Plan, which ultimately is backstopped by an EPA-administered cap and trade, same policy that Congress had failed to enact after a year and a half of deliberation. So again, if the agency is trying to do something that Congress just failed to do, I think that's another solid indication that we've got ourselves a major question at hand. So there's other possible criteria, but I won't go into them. Those are the three we had in our brief. But in a nutshell, that's the major questions doctrine. That's how it applies to this case, and that's what the contribution to the case that we made, trying to inform the court as to how it could develop this doctrine.
Can I ask a question, Joe?
Sure.
The major questions doctrine came up at a time when the Supreme Court was using the intelligible principle idea to knock down the non-delegation doctrine. And I think that the many academics and judges thought to themselves, we have to have a substitute, some way of keeping the administrative agencies from running away with these powers. And so the the question of whether this is a policy that has not been authorized became a way of treating that. Now, I think that if the court goes back to the non-delegation doctrine, and I didn't say this is what I'm talking about, but what I was talking about before, but I think they want very much to go back to the non-delegation doctrine, which they missed in the Gundy case 2 or 3 years ago. They want to go back to that. If they do, I think eliminates the major questions doctrine and things like it.
Yeah, and that's kind of what I was talking about with the push and pull back and forth between agency and court authority is over the history of administrative law, you always get a little bit of a sense that the court feels like it's restricting agencies too much, and so it backs off, and then agencies start doing something that really gives the court pause, and so we get a new doctrine that limits agency authority. But before we get into how the argument went today and how the case may come out, I wanted to mention that another limit on court's authority is, or a set of limits on court authority is standing and mootness, which are not specific issues of administrative law, but follow from the Constitution's grant of authority to Article 3 judges to hear cases and controversies. So if the court decides that a party doesn't have standing or that the case is moot, it means the court's saying that there's no real case or controversy here. And so we don't constitutionally have the authority to decide it. And the role that those issues are playing right now, I would say, is that the Biden administration does not want the court to decide this case because it's concerned about how it's going to come out and whether it's going to limit the administration's authority in here and in other areas. And so the Biden administration is arguing that the court should dismiss the case for standing or mootness issues as a way of not deciding the substantive issues that are before the court. But my first comment on how the argument went was that those arguments did not seem to get very far, even with the more liberal justices on the court who might have been looking for a way out, that wouldn't involve the court readopting or reinvigorating the non-delegation or major question doctrines. And so I'll let anybody jump in and tell me whether that's a fair assessment or how you thought the argument went today.
Just on that, I agree that's a fair assessment. The key point on that is Justice Alito asks point blank, is there any precedent for a stay to render a case moot or deprive a court of jurisdiction? And of course, there isn't one. And this gets technical for the non-lawyers, but basically what we have to understand is that the regulatory action that the DC Circuit invalidated replaced one rule with another rule. And if that action was invalid, well, then the new rule goes away and the old rule comes back. Now, as a remedial matter, as an exercise of its equitable authority, the DC Circuit can and did say, oh, wait, this could be chaotic or unworkable, so we'll press pause. But the underlying legal judgment that was embodied in the lower court opinion is that this old rule, representing a broad interpretation of the Clean Air Act, is the legally binding rule unless and until the EPA goes through the proper regulatory process of replacing it with something else. And if a lower court could deny the Supreme Court of jurisdiction by issuing a stay of its judgment, then the DC Circuit, in any case it wanted to, could prevent review of its decisions by issuing a stay, waiting for the time to petition for certiorari to lapse, and then removing the stay at the point at which such a petition could no longer be filed. And of course, that can't be right. So the jurisdictional arguments that were pushed in the briefing went nowhere. The argument that still might be there is not a jurisdictional argument. It's a prudential argument that we have an overbroad, problematic DC Circuit opinion. But reversing that opinion may bring it back into force a regulation that the agency is in the process of replacing. And what administrations often do in that sort of scenario is to ask the court, how about you vacate the lower court opinion? So if you think the DC Circuit got it wrong, vacate that, wipe it off the map, and remand it back to the agency and let us start from scratch. That didn't get a lot of time in oral argument. I think there's a slight possibility you might still get something like that. But the jurisdictional argument that the Solicitor General tried to make, I think, is going nowhere. Even Justice Breyer made absolutely clear that he just didn't get it. And he was right. It ultimately doesn't work given the details of this case.
Jim, could I just ask Professor Adler a quick question regarding whether or not, lost my train of thought. I'm sorry, move on. I had a question in mind and it'll pop into my head.
You interrupt me whenever you think of it.
Please.
I also think it's fair to say that the most difficult questions about the non-delegation doctrine and the major questions doctrine are, how do you come up with a test? I mean, Congress passes a law that gives an agency authority, and how do you decide whether Congress was telling the agent, whether what the Congress is telling the agency to do amounts to Congress outsourcing legislation to the agency or outsourcing its legislative power? And with the major questions doctrine, I mean, clearly that's a very fuzzy standard, not a rule, whether something is a major versus a minor question. And so the scenario in which I could see the court trying to take a way out without issuing a major decision is if nobody can agree on a test and they have, 7 different proposed tests, and so they kick it back and decide we're going to try and answer it another time. I don't know why it's going to get easier to answer, but I think most of the action is really in whether somebody can come up with a coherent and workable test for what constitutes a major question or a delegation of legislative authority.
Well, there's been some work on that. Of course, that's what the courts have been trying to come to grips with all along. And there's a pretty clear opinion in the Gundy dissent by Gorsuch, in which he says, look, if there's a policy involved here, this doesn't clarify things particularly, but it does take it away from the breadth of the law and take it into a question of policy. And he says, if the decision is a policy decision and it has not been made by Congress, then it's a violation of the non-delegation doctrine. And if you look at this EPA rule, and it says you can take very broad language in the statute and then say you can do something that the EPA has never done before, and that is require these power companies to go outside the fence and make investments in other parts of the economy in order to reduce the total amount of emissions they put into the atmosphere with their own money, so to speak. That seems to me to be a policy decision of major consequence. And so it should have been made by Congress, and it should be subject to the non-delegation doctrine, as I see it.
Don't disagree with anything Peter just said, but a question just popped in my head, the one for Jonathan. Jonathan, if they vacate the CAD, the DC Circuit order, would that reinstitute ACE? What are the...
No, it would. If they vacate the order, they would basically be wiping the slate clean. This is actually the sort of thing. If this weren't a climate change, this weren't a massive rule of central importance to the Biden administration's agenda. A very common thing to do when they change from one administration to the next, when you have rules that are in litigation, is for the Justice Department to basically say to the courts, look, please just clear the field for us and we'll figure it out. But figure it out in light of our new policies. The problem is the DC Circuit opinion, at least one plausible interpretation of the DC Circuit opinion, is that it embodies a definitive view of what the Clean Air Act authorizes. It's a very broad authority that arguably raises some non-delegation concerns. But yet the EPA is not defending a rule that operationalizes that interpretation. And that's an awkward posture, I think, to review a lower court judgment. And so, although the Biden administration likes that interpretation, it could have, and it kind of asks for this in the Solicitor General's brief, is to say, look, okay, fine, make that opinion just wipe it clean. It all goes away. It's as if we never had any rules and never had court decisions about them in the first place, and let us start from scratch. That gives the Biden administration a little more work to do because they can't rely on the DC Circuit opinion as a justification or a defense of what they want to do, but it addresses the immediate concerns that West Virginia and the coal producers have that there is a DC Circuit opinion on the books, which effectively forces the Environmental Protection Agency to adopt a very expansive reading of its own statutory authority.
Is the EPA right now not in the same position as the Obama EPA was in? I mean, the Obama, if I recall correctly, the Obama administration put out this original legislation. It was then stayed by the Supreme Court briefly. The Trump won the election. The EPA then was appointed by Trump. They eliminated the Obama administration, but then someone came in before the Court of Appeals in the District of Columbia and said, no, the elimination of the Obama administration rule was wrong. It should be reinstated, which is, I thought, what they actually did, didn't they?
That is what they did, and then they stayed their own mandate. So subsequent to the opinion, the DC Circuit issued an order saying, stay the part of our mandate that makes the CPP go back into place, and the justification is that the Clean Power Plan had a set of timetable, deadlines, and you must reduce certain emissions by a certain date, and so on. And those are all out of date. Some of those deadlines have passed. The nationwide degree of emission reductions that the Clean Power Plan anticipated has been achieved, but not universally. So in some states, emission reductions have been greater than the Clean Power Plan anticipated. In some states, they've been less. But the key difference is the reason the Biden administration would not be in the position that the Obama administration was is because the DC Circuit has said, right, in this opinion, EPA, you must regulate, and a narrow interpretation of your authority is arbitrary and capricious. And that stacks the deck in a way that's favorable to the Biden administration, and that stacking of the deck maintains the Supreme Court's jurisdiction. So I think if the court decides that figuring out inside the fence line, outside the fence line, what's the breadth of best system of emission reduction? Gosh, that's hard to do if we don't have a rule that is being in front of us that's being defended. Well, maybe we just wipe the slate clean and get rid of what I think. I think there's a lot in the DC Circuit opinion that disturbs and bothers a majority of the Supreme Court, because there is some language in that opinion that suggests the EPA has minimal constraints on what it does in this space, and that raises non-delegation concerns, raises major questions doctrine, raises a wide range of concerns. So I just don't. But there are other ways of addressing those concerns other than digging into the meaning of the statute. Although I should say today, the bulk of the oral argument was digging into the statute. And digging into that language and figuring out how do you reconcile source-specific language on the one hand with best system of emission reduction on the other. So, we'll see if that's the direction the court goes.
We don't have long left, and we do have several questions that I would like us to get to. The first one that I hope is quick, and I am not sure if any of us will know the answer or not because we're lawyers, is what are the implications of this case for average Americans and utility customers? And I feel like that answer would involve numbers, and I'm a lawyer because I don't do numbers. But Professor Adler, do you have any sense of what the economic impact would be?
I mean, it's hard to know because we don't know what the Biden administration's new rule will look like and how aggressive it will be. We do know that the Solicitor General said that there will be a proposal this calendar year, or that the EPA is on track to put out a new rule, but we don't know how aggressive it would be. And I should say, we do know that the decision certainly will have an effect on the coal industry and those communities that are dependent upon or that benefit from the coal industry. More broadly, I think a lot of it depends on the state you're in, right? Some states up till now have been able to reduce their emissions without increasing electricity bills, largely or not. A big contributor to that has been the relatively low prices of natural gas. There are lots of reasons, some purely economic, some relating to broader geopolitical issues that we might not depend on lower natural gas prices going forward. Some will also depend upon whether trends in cost reduction in solar and wind continue, and whether the shuttering of nuclear power plants, which continues pace, starts to have a negative effect on, or has the effect of increasing consumer prices. So there are a lot of variables that affect that. I don't know of any estimate that I put faith in on, this case means, X percent in your utility bill.
There's another question that I'll take, and then any of you can add on if you want to. Why hasn't Congress been more assertive about preventing recent presidents from usurping the legislative branch's rightful powers? Is the problem power grabbing recent presidents, or a passive Congress that won't protect its prerogatives? And I would say the problem is both. The bigger problem may lie with Congress because legislation is it's easier to make popular legislation when you're articulating broad aspirational principles. And the more specific you get about who's having to pay what price for this legislation, the more unpopular it can get and the more opposition you get. And so Congress and individual Congress people would love to be able to outsource the difficult decisions all to the executive branch. So Congress, unfortunately, does not have the right incentives to kind of defend its constitutional prerogatives and limit executive agency power normally.
Yeah, in fact, I'd add that one of the reasons for the non-delegation doctrine, one of the policy reasons behind it, is that it will force Congress to, if there's enough pressure from people for a certain kind of legislation that they would otherwise try to avoid, it will force Congress to do that. And many scholars have noticed that Congress has signed off. It's just gone away on some of the major questions that our society faces because they are afraid to make tough decisions that might cut the contributions they receive and the votes that they receive in the next election.
Yes, the good thing and the bad thing is that that Congress is democratically accountable, and administrative agencies are theoretically accountable because the president's elected, but they're much more insulated from the democratic process. So they're much more eager to exert power and impose regulations than Congress is usually.
If I could just throw in there a quick thing, agree with everything that was just said. There's also a structural problem for the non-lawyers out there. Before 1983, we had this thing called the Legislative Veto. In essence, it allowed Congress to unilaterally check executive action. The long and short of it is, for reasons I won't get into, the Supreme Court found it unconstitutional. There was 292 of these legislative vetoes on various of these statutes that create these regulatory agencies. But the long and short of it is that it's not just that our polarized Congress, one party loses interest in overseeing an executive authority whenever their guy is in charge. We've also sort of got a structural reason as to why Congress really is playing second fiddle to the presidency when it comes to major policy making these days. And again, I attribute much of that to the fact that the Supreme Court some 40 odd years ago struck down this crucial mechanism known as the legislative veto that for the first 100 years of the administrative state had been an important means by which the legislature had kept up with the Joneses when it came to competing with the presidency for management of the administrative state.
Thank you. I know our time is basically up. Let me ask, do you all have time for one more question? There's one I think is really good, but I don't want to impose on you too much. The question is, how is it possible for the U.S. to have any coherent regulatory policy on clean air or anything else when virtually every major decision is litigated and judges and courts are handing down sometimes conflicting and contradictory rulings? Is there any way to avoid such chaos going forward? And I'll add to that as like you see here, a lot of times a rule gets litigated, and by the time it gets to the Supreme Court, we're in the next administration, which opposes the rule that's being litigated anyway. And it does seem like chaos sometimes, and like it takes 6 years for an agency to regulate anything because everything has to work its way through the entire court system. Do you all think that a like clearer standard or principle articulated by the Supreme Court would help with this problem?
I mean, what solves the problem is Congress doing its job, right? They get the fancy little lapel pins because they're legislators and they're supposed to legislate. And the nature of the administrative process is if you do a regulation, you can challenge that under the Administrative Procedure Act. You can challenge whether it's a ultra vires exercise of delegated authority and all sorts of other things. You want to reduce the range of litigation, Congress can enact something in legislation that removes a wide range of possible legal challenges and creates legal certainty. Instead, like in a case like this, you have a statute that has not been meaningfully changed in 32 years. Air pollution problems, including climate change, are radically different than they were 32 years ago. And this is one of the more recently revised environmental statutes. We want clarity and rule of law in important areas like the environment. Congress needs to be in the game, and they're not.
Thank you. Do y'all have anything to add to that?
I'll just throw in it's not litigation necessarily that's coming up the works or causing instability. It's the very nature of modern regulation. That's what we've seen with this Clean Power Plan rule. Obama does one thing, it's rescinded by Trump, and then Biden comes back and does the same thing that Obama does. So there's a flip-flopping inherent to the modern administrative state. And I would say that, and I think Jonathan was getting at this, that things like the Major Questions Doctrine, by sort of closing off a wide closing off avenues of regulation, broad avenues of regulation, if you will, I think can stabilize the situation. I mean, by making it clear that you can't interpret Section 111D to institute a cap and trade or any such major policies, I think you are going to narrow the band of policies that would come out of the EPA pursuant to this provision with successive administrations. So, I think that instability is inherent to modern regulation, and two, I think these judicial doctrines, litigation, could ultimately be a mechanism by which we mollify the vacillations. If that makes sense.
Well, let me just add that there are consequences of having a democratic system, and where there isn't any large agreement among the population. There it's very difficult for Congress to act, and they don't want to act. So, and that's good. That's good, because we should be waiting for the population to come to a certain position where they move Congress to solve their problems. I don't think climate change is yet one of those issues. I don't think the American public is at all convinced that we're going through anything dangerous in the way of climate change, and Congress won't act on that.
Well, we're over time, so let me thank you all very much, our panelists, for being here, and thanks to everybody who tuned in. We had a good turnout today, and I encourage you to visit mslegal.org to learn more about the work that we're doing here at Mountain States. Thank you all and have a good day.